May it please the court, I have had the privilege of representing Jamie Komoroski for the last 18 months. And before I get into my sentencing argument, I would just like to take a moment to truly express my deepest condolences to the Miller family, the Hutchinson family, the Garrett families. For my entire defense team, as well as the Komoroski family, we are truly regretful that you have to go through this. And I hope that your injuries will eventually clear up, and I'm so sorry that you have lost Samantha in your lives, and I mean that genuinely. Our entire defense team and the Komoroski family cannot fathom the pain that these lovely families are going through. And while we know it's never enough, we genuinely convey those deepest sympathies and prayers. And I want the court and everyone in the courtroom to know that Jamie has heard the calls for punishment. And as you will soon hear, she recognizes those calls are justified. Punishment is one cornerstone of our criminal justice system. And punishment is warranted here. No one is contesting that. Most importantly, Jamie. And we also recognize that punishment serves deterrence purposes. It ensures that people are accountable for crimes that are committed, especially those that, like in this case, involve victims. Here has been highlighted a beautiful bride lost her life, and several were seriously injured. And that's, as I mentioned, that is not lost upon me, the Komoroskis, or our entire defense team, Your Honor. We also just respectfully ask this court to equally consider various other sentencing factors that are likewise cornerstones to the criminal justice system. Factors that we submit are material of fashioning an appropriate sentence here. And those factors necessarily include Jamie's history, her character, her rehabilitative potential, which must be equally weighed with the needs to protect society, to deter, and to punish. It is my hopeful goal to convey to this honorable court that there is more to Jamie than just the person who committed these terrible crimes and who made these terrible decisions on April 28th. Jamie is a 27-year-old girl who stands before this court with no prior criminal offenses. She's never before been charged with a crime, save a couple minor traffic violations, never even been disciplined for a single infraction. Through her entire life, Jamie has maintained a warm and caring outlook on life for all those around her. She's strived to help others even from a young age, entrusted by so many to care for infants and young children in some of the families where she grew up and in the Charleston metro area. This compassion and care is what caused Jamie to volunteer annually in high school to support the Special Olympics, a cause that was near and dear to her heart since she was a young child. As the court heard, Jamie attended college in Coastal Carolina and obtained her Science and Business Administration degree. And she ended her career at college on the dean's list, ultimately moving to Charleston after graduating in hopes that there would be employment she could sustain. Maintaining full-time employment, like for so many others, proved elusive for this young graduate. But instead, Jamie took a number of part-time jobs, including continuing babysitting services and working in the service industry in and around the Folly Beach area. Now, sadly, since her college graduation, Your Honor, Jamie has struggled with the demons of alcohol abuse. That is obviously clear here today. And this is something that has likewise challenged her extended family. Jamie was abusing alcohol on a near daily basis, and oftentimes well over in excess. And her addiction, I want to make this point very clearly to the court. It is not offered as an excuse to her conduct whatsoever, or to make it appear that she somehow is the victim. We all recognize, most importantly Jamie, that that is not the case. She knows no one forced her to drink or drive a car. She, more than anyone in this courtroom, knows that. And I raise this only to demonstrate that her alcohol addiction, the level and scope of it, played a central role in how we arrived here today. As the court is well aware, this is unfortunately not a unique tale for those who struggle with alcohol abuse. Jamie undoubtedly made a tragic and terrible decision to get behind the wheel of a car on April 28th while significantly intoxicated. And it was her decision and no one else's. And I can tell you, after talking to Jamie on a near daily basis during the entire course of my representation, this evening continues to haunt her, and it will continue to do so for the rest of her life, no matter what happens in this courtroom today. Every day, Jamie tells me she wishes she could go back and change what she did, to shake that young girl to her senses. Even Jamie will admit that she doesn't recognize who she was back then, a sentiment that candidly even friends have shared, but unfortunately she can't. Now, Your Honor, it's often been said that character is truly demonstrated in times of struggle and failure, not in times of success. And in that vein, and in that concept, I ask the court to consider Jamie's actions and behavior since these tragic events of April 28th, in addition to her personal history and characteristics. Jamie has not approached this with a woe is me attitude or felt sorry for herself or tried to endorse any victim mentality. Instead, she immediately accepted her addiction and embraced the need for alcohol treatment. And while there were inherent limitations in the substance and depth of that treatment, she did what she could.
When you say inherent limitations, what are you referring to?
She was not able to be visited by a therapist while she was at Alcannon. And based on the
How long was she at Alcannon?
she was there for a year. The court will indulge me for one moment. From April 28, 2023 until her release on March 1st, 2024.
Is there a reason she didn't avail herself of the programs at the jail?
The programs are very limited based on the ability to communicate with inmates there.
No, there's a peer program, the 16 weeks that's available. Someone could have asked it if you ordered. She could have well taken advantage of that.
No, Your Honor, to be sure, she did. I'm talking about more substantive treatment, which obviously...
Here is a substantive program. You know, like
she did avail herself.
She did do the peer program?
Yes, ma'am. Excuse me, Your Honor, one second.
Did she do the peer program, Mr. Williams?
It's the peer program.
It's an acronym, PIER. It's a substance abuse intensive program that's 16 weeks at the jail. It's offered by Charleston Center. It's substantive drug and alcohol treatment.
It was never offered.
You have to sign up for it. We'll come seek you out. Yeah.
I do not.
So she did not. Okay. You may continue.
I apologize.
That's okay.
Jamie, as the court heard, she's been participating in AA meetings while detained at Alcannon, and since her release to restricted house arrest, in participating in meetings 6 days a week. She has hosted in-person meetings at her apartment every Friday, and also chairs an AA meeting on a weekly basis. Jamie has also volunteered to answer the AA hotline once a week, trying to offer steady and experienced counseling to individuals who may be in crisis.
So why didn't she try to get some inpatient treatment? What was the impediment to that? Or having something, not that I'm knocking AA because I don't, it is a, for many, it is a great program that assists them, but it usually follows something more substantive, such as intensive inpatient treatment or ongoing intensive outpatient treatment. And I think that's the question that I'm more interested, or most interested in hearing. When you say someone's availed themselves of substance abuse treatment, I expect something more than AA.
We attempted to do that, Your Honor, when we had her detention or bond hearing. In fact,
She's been out since March 21st, so let's go from there forward.
an extremely restrictive house arrest, and as I understand it, unable to facilitate the visits unless we were to go to a facility where
Which
she
you
could go
could
to
have
the
asked for
facility.
permission to do, correct? And so that's what there was no attempt to have any type of treatment of that sort.
Endorsement of that permission from the state was not forthcoming, Your Honor.
Did you ask?
We did, we had those discussions.
Okay. Did she make any attempts to have any online therapy?
As best as she could, Your Honor. Yes, ma'am.
You may continue.
Thank you.
You're welcome.
While detained at Alcannon, she obtained a professional skills credential from South Carolina Works in digital literacy while she was detained. And following her release under the House release conditions, as she alluded to, she's been working 2 jobs, trying to continue to be a contributing member as best as she could under those circumstances to society. She worked remotely as a web designer, and then one colleague through AA was so compelled by her that she hired her as a remote digital marketing assistant, which I am told is a job that she can avail herself of ultimately when she is released. As you'll soon hear from Jamie herself, she deeply regrets these decisions that she made on April 28th. And since the day we were retained, she's been heartbroken for Samantha, Aric, and the families that were involved in this ever since the crash. It's important, and I know she wants me to express this, that she is a daughter and sister, and she has, since day one, expressed her sorrow and remorse for the actions that she committed. This has been Jamie's goal and intention ever since we were retained. But on the advice of counsel, we recommended that she hold back on that. There was a period of time where discovery was not available for a while, and any delay in this guilty plea should be attributed solely to our obligation, our ethical and professional obligation to explore defenses and mitigation possibilities, not because of Jamie's failure or unwillingness to plead guilty and exhibit remorse and accept her responsibility. One instance, as attached in our sentencing memorandum, related to a time where we needed to retain a blood alcohol forensics toxicologist to review the state's findings, and we have attached counter findings to that.
Did you all provide a hard copy of the mitigation packet that you provided to the court, to my law clerk today? Mr. Williams indicated he planned to bring one with him.
Yes, sir, we have one.
And do you wish to have that filed?
We have a
Or did you
redacted-
already file them?
we have a redacted version of the file and a redacted version of the report.
Yes. You may continue.
Thank you, Reverend.
You're welcome.
As I referenced, we included findings of our forensic toxicologist who was retained on behalf of the defense, but I want to emphasize that regardless of that lower BAC, that Jamie recognizes the gravity of her crimes and has consistently shown unabated remorse for her actions. I offer that only for the court's consideration in the context of mitigation, and we certainly recognize that regardless, it is above the legal limit. Your Honor, taking all this together, we respectfully submit that Jamie has demonstrated and continue to demonstrate strong rehabilitative potential. And the prospect of her rehabilitation and restoration to a useful place in society, which are key legitimate interests in sentencing, is unquestionable. As you will hear from Jamie herself, she will never be an offender in the criminal justice system again. She continues to work on bettering herself and improving herself following these terrible acts. She helps others by sponsoring and paying her terrible story forward of what happened to these families and seizing any opportunity to help other alcoholics in an effort to prevent further unnecessary death or injury. So, Your Honor, we ask that you consider these sentencing factors equally with the obvious need for deterrence, protection, and punishment that has been alluded to. We have cited for the court's consideration as it see fits numerous empirical studies that show that there is limited relationship between sentence length and general or specific deterrence. And it actually demonstrates that longer incarceration could potentially be counterproductive for the types of individuals who have no criminal history like Jamie. But again, I leave that to the court's consideration. As I open with, Jamie recognizes that she is due a punishment for her crimes today. The court, as you heard me say, she's been detained at Alcannon from April 28, 2023 until her release on March 1st, 2024. And since her release, she's been fully compliant with the terms of her monitored house arrest. Pursuant to South Carolina Code Section 241340, we respectfully ask that the court grant Jamie credit for her time served under strictly monitored house arrest, of which she's had no violations. And should the court agree with that request, it would give Jamie a total of approximately 580 days jail credit as of today.
When was she released and placed on monitor?
March 1st, 2024. Thank you, Your Honor.
You're welcome.
Incorporating this credit, we only ask that the court fashion a sentence that's sufficient but not longer than necessary under these circumstances. It is genuinely hoped by Jamie and by all of us and her family that while she caused this great tragedy, her actions on this one day of her 27-year life will not solely define her as a human, and the court will see that. Prior to becoming a defense attorney, Your Honor, I spent the bulk of my professional career as a federal and state prosecutor, including 10 years as an appointed district attorney. And I had the unfortunate obligation to determine countless plea offers in felony DUI cases in a dense jurisdiction of nearly 700,000 people. And sadly, these types of cases were not an uncommon occurrence. To be sure, these are the most difficult, gut-wrenching cases to assess. And as is the case here, defendants are typically people who have lived very productive lives with no criminal record. And I just want to highlight that what I believe the court is familiar with. These defendants don't set out to commit crimes with malice or evil in their hearts. But nonetheless, those actions that they take have destroyed or taken lives. Balancing the interests of the state, the victims, and the defendant is extremely difficult. And Jamie here is no different. She has chosen to plead guilty to her crimes without the protection of a plea agreement. The court should see this, I hope, as evidence of Jamie's genuine remorse and acceptance of responsibility for her actions. She never intended to challenge these charges because she knew what she did was wrong the minute that it happened. She would never put the Millers, the Hutchinsons, or the remaining family members through the pain of a trial, having gone through what they already have. Your Honor, I say the last concept for what I submit is the most fundamental cornerstone of the criminal justice system, and that's mercy. Mercy is not often spoke of in the courtroom, but the courtroom is precisely where the place where mercy should exist, especially considering the nature of felony DUI cases where tragedy exists on both sides of the V. It is difficult to keep mercy at the forefront, especially when a beautiful life like Samantha's has been taken and wonderful people that stand and sit behind me have been through what they've been through. But I humbly submit this is where mercy plays the biggest part. Jamie and our defense team are not arguing for release. As stated, we recognize that punishment is warranted here. What we simply ask the court is this 27-year-old girl with no criminal history, who struggles to face the demons of alcohol abuse, and who made a tragic error in judgment to drink and drive, who has no history of violence, and who most importantly has regretted and has been remorseful for her actions since the moment she committed them. Is this girl deserving of the court's mercy? We humbly submit the answer is yes, and under these circumstances, ask the court to properly fashion a sentence that is sufficient but not greater than necessary to punish the conduct here. Jamie's a young girl who made a truly terrible error in judgment, and there but for the grace of God go us all. That concludes my argument, Your Honor. With the court's permission, I would invite some of the members of the Komoroski family and other supporters to address the court.
I have a list of 7 people. Is that, well, not including your client, I have a list of 6 people. Is that who you're referring to?
Yes, ma'am, it is.